Do you recall? I'm trying. What, if anything?
I'm trying. I'm trying. I'm doing my best here. As long as she's trying. As long as she's trying. Oh my. All right, we are back at it with the review and reactions. In the last video, I reviewed and reacted to a moment in the Amber Heard and Johnny Depp trial that went viral involving a lawyer objecting to his own question and making the hearsay objection, and we broke that one down. Now, the video we're about to go through and review and react to is still part of this Johnny Depp versus Amber Heard trial because it's a lot of good content that we can create really concrete tips, tricks, and advice on. And this one caught my eye because it involves objections. If you know me, I'm a trial lawyer. I own Stone Firm P LLC, and I'm all about objections. In fact, I have the free objection cheat sheet, which should be sliding above. That goes through the 21 most common trial objections, breaks it down, super easy, puts it all on a single page for you. Also goes through the responses and the quick summaries on each of those objections to really get you oriented if you're new to trial objections. But as we're about to learn, when it comes to trial objections, when you're in the courtroom, you got to be on your game. Trial objections are the sword and the shield for any trial lawyer. And this means that when the moment arises, you got to think lightning quick, and you almost have to have a second nature reaction to objecting and or responding to your objection, and then supporting either that objection or that response if the the judge allows for it. In this one, what I'm going to do is go through the moments where objections are made and provide my reaction to each objection, because I have a feeling based on the first 3 minutes, some of the rulings the judge was making wasn't particularly correct, I'll say. And some of the objections didn't seem super valid. Some of the justifications seemed a little confusing. All that and more coming up.
I mean, not until December and my best friend taking pictures of me to capture it that wasn't even a thing.
This is interesting. So Amber is doing, I say Amber like I know her, Amber Heard, Miss Heard, is doing a great job in my mind of turning and directing part of the conversation to the jury in the hopes that the jury feels engaged in that conversation. But the interesting part was during that 3-minute watch period before filming this, I also scrolled down in the comment section to kind of see what the vibe was. And well, one, people don't seem to be too much of a fan of Amber Heard. And two, there were a lot of comments about it being creepy with her turning to the jury to direct her answer to the jury, which is interesting because we were trained, at least from mock trial, even to as a lawyer, that you always want to instruct your witnesses to engage the jury by making eye contact. So I don't know if it's just the aspect of watching someone from a video camera to where it seems awkward that she's looking away and not at a video camera or to the person who's asking the question, or maybe in today's world it's a little bit too intrusive to be locking eyes with jurors who are analyzing the case. That's interesting. I would have assumed that she was doing a good job with that, but the amount of comments I was seeing saying that was creepy and off-putting was surprising. So definitely something to think about when it comes to an upcoming trial you may have, and when it comes to preparing a witness or a client for testifying.
It has been suggested by Ms. Vasquez to you in your questions that you didn't tell anyone about the abuse until the TRO. Is that true?
Objection, Your Honor. Leading.
All right. What if any? All right. Who did you tell about the abuse during the time it was happening?
Objection, Your Honor. Leading.
That's not offered to.
And hearsay.
Sustained.
Your Honor, it's prior consistent statements.
It's leading. It's sustained. Next question.
Okay.
I don't know why the judge sustained that question for leading. Who did you tell? This isn't a leading question. A leading question assumes the answer within the question itself. For example, like, you are watching a YouTube video, correct? It assumes you are watching a YouTube video. And so asking who did you tell is asking for names. So I don't really know how that would be leading in that situation. It may assume facts not in evidence if the second half of the question hasn't been introduced into the record. That'd be a different objection. But leading on a who, what, when, where, why, and how doesn't really make sense to me. So I don't know if I agree with the judge on this one.
What, if anything, did you tell to anyone about the abuse?
Objection, Your Honor.
therapist.
Hearsay.
I'll sustain
Your
objection.
Honor, may I approach him?
That's fine.
This is interesting. What did you, as the witness, tell someone that really is going to test your knowledge on hearsay? And if you're new to hearsay, check out the guide to hearsay that really goes over the hearsay basics. And I'll also slide another video that goes through the step-by-step process of analyzing hearsay. Hearsay can be a gauntlet. It's a test instead of like, hey, this is always hearsay. Instead, you always have to look at the context of the statement. In this situation, with hearsay being an out-of-court statement offered to prove the truth of the matter asserted, Amber sounds like she's about to, I say Amber again, Amber Heard is about to quote herself on a statement she made outside of the courtroom. So you have an out-of-court statement in that scenario that could definitely be considered hearsay if she's attempting to prove it for the truth of the matter asserted, or offer it for the truth of the matter asserted. So what's happening now is that both attorneys are approaching the bench to probably argue the context of what Ms. Heard is going to say. And in doing so, the judge is going to have to determine whether or not it is being offered for the truth of the matter asserted. If you don't know what truth of the matter asserted is, I'll slide a video above for you to check out. And we'll see the result of what the judge says based on the context of probably what the lawyers are arguing.
Ms. Heard, how many people have you shared the fact of abuse prior to 2015?
Objection.
Okay, so the fact that she asked a different question and a new question tells me that the judge sustained the objection. Sorry for cutting off the objection that apparently is on its way, so let's back it up a little bit.
How many people have you shared the fact of abuse prior to 2015?
Objection, Your Honor. Leading.
How
Calls for
many?
hearsay.
How many?
Overruled that one.
Okay, so the judge did the right thing here. How many? It's an open-ended question. It doesn't assume the answer in the question. Who, what, when, where, why, how. Those are all open-ended questions. This is redirect. Open-ended questions are what should be happening. You can't have leading questions on redirect. So the objection wasn't good in this situation, and I'm glad the judge overruled it.
Roughly about 10.
Can you name them?
Yes.
Objection, Your Honor. Hearsay.
I think she can. It's not offered. It's just to show that she informed people before. They're suggesting.
Objection, Your Honor. Can we approach? This is, again, inappropriate.
I don't know how "can you name them" is hearsay. That doesn't really make sense to me. Can you name them? Yes. No. There's no out-of-court statement being said in that testimony, so I don't really understand that objection either. I also don't, by the way, I was about to start it. I also don't understand the response from this attorney on redirect, Amber Heard's attorney. She immediately dives into, this isn't being offered for the truth of the matter asserted. No, that's not the response. The response is, this doesn't call for an out-of-court statement. This calls for a yes or no. I know leading questions tend to call for a yes or no, but this one, can you do this, is not suggesting the answer within the question, even though you still get it like a yes or no answer or result from it. So a little tricky there, but I think that made sense.
Now, you were asked whether
I don't really understand what's happening because she's the redirect attorney, Amber Heard's attorney, is moving on to another question, which makes it seem like the judge sustained the hearsay objection. And again, it's not hearsay. So I don't really understand that unless the lawyer forgot what her question was and just is moving on to what was next up on the list. I don't know. That's really weird.
You had consulted a medical doctor about any problems with your nose, correct?
That's correct.
And you indicated
That is a leading question.
that you in fact had after the divorce,
Objection leading.
Did you or did you not consult an ENT after the divorce?
Objection leading.
Did you?
Okay, so what just happened there? Initially, it was leading, and then by asking, did you or did you not consult an ENT? That is a poorly worded, open-ended question that's going to be judge dependent. But typically, I think in my experience, judges tend to lean in favor of that being open-ended. It's not very open-ended, and sometimes some attorneys take advantage of that and they say, did you do this? Did you do that? Did you do this? In order to get a yes, I did this. Yes, I did this. Yes, I did that, which is in essence asking leading questions pretty consistently throughout the direct examination. So in my opinion, you don't want to have too much of a quick trigger on this objection. If they throw out a did you do this or did you do that, I let it slide, but if it becomes like a crutch for the lawyer on direct or redirect, then make the leading objection, ask that opposing counsel open up the questions in order for it to be a little bit more appropriate during redirect and direct.
After the divorce,
Objection leading.
Did you or did you not consult an ENT after the divorce?
Objection leading.
Did you produce?
Notice that the lawyer making the objection isn't getting a ruling from the judge. If you feel like this is an important objection that needs to be made, you may want to stand up and ask for a ruling from the court.
Did you produce medical records to the defendants relating to this?
Objection leading calls.
I'll sustain the objection.
Thank you.
Leading. Next question.
Your Honor, witness could be instructed not to answer until I've
All right.
lodged my objection.
Wait for the objection, please.
Could we bring up defendant?
Okay, so things are getting a little sloppy right now. Everyone's talking over everyone. It looks like, based on what I was saying, that the judge's tolerance of did you or did you not do this was hit to where if the opposing counsel in that situation is going to use that as a crutch, then the judge just said, no more, crutch is gone. I'm going to sustain it as leading, basically telling the redirect attorney to open up the question.
Exhibit 1077. Do you recognize this document?
My screen is black.
Oh, sorry. Wait.
Yes, I do.
And could you tell us what it is?
That's the what my ENT, the ears, nose, and throat doctor, told me was
Objection, Your Honor.
the
Hearsay.
damage.
All right. When there's an objection, please stop talking. Thank you. All right. I'll sustain the objection as to hearsay.
Okay.
This one just confused me. The judge seemed a little too quick to sustain this objection. I'm a little baffled by this one. So, Ms. Heard in this scenario is referring to an out-of-court statement made by her doctor about either injuries or diagnosis of some sort. So you have an out-of-court statement that's most likely being offered for the truth of the matter asserted. But there is an exception to this hearsay rule that allows statements like this to come in. This exception is basically the medical diagnosis exception. Let me make sure I can cite to it directly. This is Rule 803.4. I couldn't remember which specifically it was, but it's a statement that is made for and is reasonably pertinent to medical diagnosis or treatment and describes medical history, past or present symptoms or sensations, their inception, or their general cause. I don't see how this exception would not apply. And so I'm a little baffled by the judge immediately sustaining this objection, unless this has been haggled out outside of the clip that we're watching and they somehow determined that this exception didn't apply earlier. But I think the judge may have goofed on this one.
Okay. What, if any?
Oh my goodness. That pause felt like an eternity. Okay. I'm going to go ahead and stress the same thing that I've been saying in this video and the previous reaction video. Know your objections. Know the important evidence you need to have from the witness stand. And when it comes to that important evidence, anticipate what the objections are. And if you can anticipate what the objections are, come up with responses and put them in your back pocket. If this is important testimony of what the ENT stated to Miss Heard, then in that situation, you should probably know that there could be a hearsay exception that applies and make that argument. This is a rough going when it comes to knowing the evidence involving the facts here, but we're going to push through.
You were asked if you had, it was suggested that you had not produced this in discovery. Is that true?
Objection, Your Honor, leading.
Your Honor, she absolutely did that.
It's leading. It's leading question, though. I'll sustain the objection as to leading.
What, if anything, did you do to produce medical records to the defendant, to the plaintiff in this case?
I turned over all of my devices, and they had Johnny's team had a third party or someone they selected as a third party go and pull all relevant documents from those devices, which I handed over.
Do you know how many were handed over?
Hundreds of thousands, I believe. Maybe.
Objection, Your Honor, lack of foundation.
All right, I'll sustain the objection. Next question.
And do you,
Not sure I
what,
understand
if
that one.
anything, did you produce to the plaintiff in connection?
Is that supposed to be assumes facts, not an evidence? I don't really understand the lack of foundation, but this is redirect, so I'm not exactly sure what other evidence has come out during this witness testimony. That one was a little weird.
And do you, what, if anything, did you produce to the plaintiff in connection with your consultation with an ENT specialist relating to your nose?
Objection, leading.
Sustain.
What, I said, what, if
Foundation,
anything,
here.
You know what? As a judge, I don't think I would have sustained this as leading. What, if anything, did you produce? That seems pretty open-ended. What did you produce? It could be 100 different things. It could be 4 different things. It's not suggesting any answers. I think maybe where this redirect attorney is going wrong is just by having long-winded questions, and it just, in the moment, seems like it's leading. But it doesn't sound like a leading question to me. But if you disagree, let me know in the comment section politely, please.
And as a result of that consultation, what did you learn about your nose?
Objection, Your Honor, hearsay.
I'm not asking her to tell what they said.
No, I'll sustain the objection.
What is happening? I don't get it. Please tell me she makes the argument. Come on. No? Nothing?
What, if any, production?
Oh, my goodness. So she's asking, what did you learn by going to the doctor? What was your diagnosis? What was your treatment? And of course, she learned this from her doctor making an out-of-court statement to her. But we have a hearsay exception that applies. We've already talked about this. What did you learn by going to the doctor? Was it a medical diagnosis? Was it a treatment? The only thing that I could think of is the judge doesn't think it's reasonably pertinent, but it sounds like that would probably be the case. Again, I only know as much as the video is showing. I just don't see how this exception doesn't apply. If I'm wrong here, if it does not apply, and if you know more than me, again, comment section down below. I'd be happy to see what the counterpoint here and the counter argument is to why this exception doesn't apply. But I'm probably even more disappointed in this attorney who's asking the questions for not making this argument. Doesn't make sense to me. Okay, let's go ahead and move on.
Okay. And do you recall? I'm trying. What, if anything?
I'm trying. I'm doing my best here. As long as she's trying. Oh my goodness. I have no words for that. I have no words. I gotta replay that. Let's run that one back. Oh my goodness. I'm getting hot. It's getting sweaty in here. Oh my goodness.
The records, medical records from your EMT were produced in discovery in this
Objection,
case.
Your Honor. Lack of foundation calls for speculation.
I'm asking.
Overruled if she knows.
Thank you.
Yes.
Okay. And do you recall? I'm trying.
Gets me every time.
What, if anything, did the medical records reflect about your nose?
Objection, Your Honor. Hearsay.
I'll sustain the objection.
You know my thoughts about this.
Do you have injuries to your nose?
Yes.
Please describe those to the jury.
Good job.
I have
I'm going to
a bunch of
object
scar
to
tissue.
I'm going to object to the extent it calls for hearsay and lack of foundation
Overruled.
and improper expert opinion.
Well,
She can certainly testify too.
we'll see where it goes. Go ahead.
Okay. Go.
That's the right ruling by the judge. I don't necessarily understand the objections from Johnny Depp's counsel on that one. The only one I do kind of understand is calls for an expert opinion. So if Amber Heard starts talking about more than kind of what she was told, hearsay exception, applying in that situation, and starts saying, and this could result in this, or this could result in that, and starts opining, then she's kind of starting to lean into expert doctor territory and opinion. So it's a good objection on that last one, but I think the judge is doing the right thing by allowing the testimony to go and basically saying, to Johnny Depp's attorney, you can make that objection if that starts coming out.
I have a significant amount of scar tissue in my nose.
Objection, Your Honor.
I'll sustain the objection.
She don't even say what the objection is, and it gets sustained. I don't really know what's going on there. Again, we're dealing with a medical diagnosis. I am a little confused by this. I don't understand what just happened. Maybe I'm crazy. Maybe I'm the one who's wrong here. This doesn't make sense to me.
What, if any, difficulty do you have breathing?
Objection, leading.
What, if anything? And that does cure on
No,
it.
it doesn't. But I'll overrule the objection.
Thank you.
Okay, this is not the right objection. I think basically what's going on here is, again, assuming facts, not an evidence. Do you have difficulty breathing? That's more open-ended question. She says, yeah, I do. The problem is when I breathe, I can't breathe through my right nostril or something like that. Or if she says, yes, I do. Okay, can you explain that to the jury? Follow-up question, more open-ended. I think technically Amber Heard's lawyer here is correct that it's open-ended. It's not a great open-ended question, but it does assume facts that haven't been established from what we've seen thus far. So that's the objection I would have made. That's the objection that probably should have been sustained, asked to establish that foundation a little bit more.
Do you remember the question?
I have a significant amount of trouble breathing at night, and I've been putting off having surgery for it.
Now, you were asked about December 15, 2015, and Ms. Vasquez suggested that you did not report the abuse or the injuries to Aaron Filati. Do you recall that
Objection, Your
question?
Honor. Leading.
Your Honor, I'm entitled to go into what Ms. Vasquez asked.
The objection is leading. I'll sustain the objection.
Okay.
The lawyer is just asking lazy questions, or she's not putting a lot of thought in her questions to make them more open-ended. Again, I would start with, do you remember testifying on cross-examination about this? Yes. Okay. What did you report whenever that occurred? And then that's a little bit more open-ended.
We've heard testimony about Mr. Depp making a total of $65 million in 2015 and 2016 from his experts.
Objection, Your Honor.
Why did
Leading.
I haven't asked the question.
Hearsay. I mean,
Why did you not ask for $32.5 million from Mr. Depp?
Your Honor. Leading.
That's not leading.
I said, why did you not ask?
And relevant.
I'll sustain the
explanation.
objection. Sustain the objection to leading. Next question.
Why can I just
That's a little weird. I don't understand sustaining that one. That's odd.
ask, why did you not ask for $32.5 million from Mr. Depp?
Because I didn't want
Asked and answered. Relevance.
Oh, overruled. Go.
I don't know. I don't know how it'd be asked and answered if it was just sustained and she wasn't able to actually answer it, and then throwing in the objection of relevance is a very low threshold to satisfy relevance. So, yeah, that's a little weird. But I'm curious on your input here. We've been going through this video, and Johnny Depp's attorney is objecting to anything and everything, basically. I would say 97% of these questions are getting objected to. Some of them justifiably so. Some of them gray area. Is it worth really objecting to? Other ones, I'm like, why are you objecting? So I'm going to pose it to you right now. Does all of these objections come off as off-putting? Does it feel like Johnny Depp's attorney is trying to hide the truth? Or does it seem the complete opposite? It seems like Johnny Depp's attorney in this situation is really trying to battle it out so the truth can come out and the inadmissible evidence can't come in. I'm curious on what your thoughts are. Let me know in the comment section down below.
because I didn't want it. I realized that that's what I was entitled to, but I didn't want it.
Let's go ahead and wrap this one up. It's just difficult for me to go through this. There's a lot of cringing on my end, and there's a lot of secondhand embarrassment on my end. But if I really break down my reaction to this, I'm disappointed with the lawyer who's conducting the redirect. She needs to have in her bag responses to these objections so she can adequately argue why she should be able to ask some of these questions. Granted, some of the objections being made by Johnny Depp's attorney are valid and they should be sustained. But as you could probably get a sense, there were other objections that should have been overruled that the judge got incorrect, and it probably would have helped the judge lean a little bit more in favor of getting the right ruling if the redirect attorney was able to properly argue the response instead of floundering a little bit and struggling with handling things like hearsay and other types of objections. So let me know what your thoughts are. How do you think each lawyer did? How do you think I did? Do you think I missed some of these objections? Do you think I was incorrect? Let me know in the comment section down below. If you're new to Law Venture, consider subscribing. If you're still watching at this point, I appreciate you. Be sure to hit that like button down below. Liking a video allows us to rank higher, ultimately reach more people, ultimately help more people, and that's always the goal. With all that said, I'll see you in the next video.